in a voting area to obtain ballots as provided by law. And that statute is being repealed with this bill.
Further questions of the reviser? Representative Bishop.
Are we supposed to get a copy of the bill?
It is online. So if you go to the Kansas Legislative website, you can pull it up as House Bill 2183, and then that is where you'll find the language. We are a fully electronic committee, so we are not providing paper bills and physical copies like you've seen historically in the past from legislative committees. You're welcome, Representative Bishop. Representative Neighbor.
Thank you, Mr. Chairman. So this only touches upon the powers of the governor during an emergency. Is that correct?
Supervisor Heim.
It's not restricted to emergencies. It basically says the governor has no authority to alter election laws or procedures by issuance of an executive order. So it's arguably the governor doesn't have that power now. But does that answer your question?
It does, but this also includes the judicial branch in this. And so, you know, we have 3 branches of government and they're there for a checks and balance reason. And I'm just wondering why all the power should come to the legislature when we have 3 branches of government. Now, if the governor doesn't already have that power, that's one thing, but I think the courts certainly have, should have some input in this because they enforce the laws that we have written. So it does the same thing to the judicial branch, is that correct?
That's correct. I'm not sure the bill would be effective in preventing a court from declaring some election law unconstitutional, however. So basically, I think the thought of the bill is, or the intent, maybe not artfully drafted as it stands, was that the without, I guess, unusual circumstances, and even then, the governor would be bound by the state election laws. It would be up to the legislature to basically change them. I think you get into a little bit of a, as you point out, trying to harness the judicial branch. I'm not sure this bill is effective in doing that, but
If their powers are taken away, then it's going to be strictly run by the legislature. So if for some reason we have an emergency in there and the legislature is not in session, it ties the hand down to one branch, which I think, you know, the judicial branch at least is supposed to interpret the law as we have had it written. And that's certainly a choice of the representatives to set that law. But I think there needs to be also an oversight on that so that it is interpreted the way the law is written.
Representative Proctor.
Thank you, Mr. Chairman. The question for Mike. So the bill talks about the powers of the executive or the judiciary branch to alter election law. Is there a statutory or constitutional difference between altering and striking down a law as unconstitutional, which would be the responsibility of the Kansas State Supreme Court?
I think you could argue that there is a difference between altering and striking, but this is a statement bill in terms of policy statement is the way I read the thing, to the extent that it limits the power of the judicial branch.
Okay, are there further questions from the committee? Representative Topliker.
Mike, am I wrong in reading this that the Legislative Coordinating Council would have, could still agree or sign off on some sort of a decree by the governor or Secretary of State? Could the LCC sign off on it still?
No, the way the bill was written, it deals with consent decrees issued by a court. So if the legislature is going to sign off on something that the governor or some other executive branch would try and do in terms of elections, I believe they would have to do it by legislation.
Okay, Mr. Chairman, if I could, I'm just, I'm looking at the in the title. Maybe I'm just misinterpreting, but it says limiting the authority of the Secretary of State, whatever, with any court without legislative coordinating council approval. So to me, that the way that's written sounds like if the LCC signs off, that they could do it. Is that, am I way off on that?
No, you're reading the bill correctly as well as the title.
Are there any further questions of the reviser? Representative Lehan.
Thank you, Mr. Chairman. Remind me again, Mike, what is KSA 25622? What does that statute say?
That's the current law that basically says that in times of emergency, the Secretary of State, if there's an issue getting ballots or whatever, that they have the ability to, and let me get the statute back here.
I've got it in front of me. It's one sentence if you'd like me to read it.
You have it pulled up. Go ahead and read it, Representative.
Ballot distribution in times of disasters or emergencies. The Secretary of State may designate temporary alternative methods for the distribution of ballots in cases of war, natural or man-made disasters, equipment failures, or other emergency conditions or circumstances which make it impossible for voters in a voting area to obtain ballots as provided by law.
Thank you, Representative. Did that answer your question, Representative?
Yes, thank you.
Okay, Representative Neighbor.
Thank you, Mr. Chair. But in C, in this bill, it says the Secretary of State shall not enter into any consent decree or other agreement with any state or federal court regarding the enforcement of the election law or the alteration. So that takes his power away from doing that. Is that correct?
The reviser can back me up on this, but if you continue to read in subsection C there, it continues and then it says, without specific approval of such consent decree by the Legislative Coordinating Council. So basically, the Secretary of State would have the ability to enter into a consent decree, but would have to have the permission of the Legislative Coordinating Council to do so.
Okay, then when you go back to where it says an act, and in that it says with any court without legislative coordinating council approval. So in the beginning of this, the legislative coordinating council, as this reads, has no control, and now you're putting in C that they do have control in this condition.
Can you restate the question?
Okay, where it reads an act in the very first part, at the end of that paragraph, it says, with any court without legislative coordinating council approval. That means there is no LCC requirement for approval. Is that correct?
Currently, you are correct. There is currently no oversight. There's nothing when it comes to the Secretary of State entering into a consent decree with any parties under current law. That is correct.
Okay, and then it goes down in section C, which is where I'm looking, where it says enforcement of any election law or the alteration of any election procedure without specific approval of such consent decree by the legislative council. To me, that says they don't have the power to sign it, and now they do. So is that, doesn't make sense to me. If LCC has no power over them in the beginning paragraph, all of a sudden we're giving it to them in section C for this particular thing? That's the way I read it.
Mike, if you could provide clarification.
Let's read subsection C because that's the section. It says Secretary of State shall not enter into any consent decree or other agreement with any state or federal court regarding the enforcement of any election law or the alteration of any election procedure without specific approval of the consent decree by the coordinating council. The Secretary of State's office can probably give you some examples of consent decrees that have been entered into over the past years. One that I recall, I believe, was a consent decree in terms of who could circulate petitions in the state of Kansas. And the state law provided that you had to be a resident of the state. And there was a court case, I believe, in Oklahoma that said that was an unconstitutional violation of the U.S. Constitution. And so I believe it was a consent decree that the Secretary of State's office entered into in terms of not requiring that you be a resident of the state in order to circulate a petition. A few years later, we amended the law to basically mirror what that consent decree held. There's probably other examples, but I'm not really following what Representative Neighbor's interpretation of the bill is.
May I ask him a question, Mr. Chairman? Thank you. Mike, my question is, in the first paragraph, that starts an act, it ends by saying...
The first paragraph where it says an act is the title of the bill.
That I know. I'm just telling you where I'm reading from, okay? At the end, it says without legislative coordinating council approval. So it says that we can do that without legislative coordinating council approval. That's what it says there.
Well, you're getting confused with the title of the bill, which is an important part of legislation, but it's not part of the actual law itself. And you read the title separate from the guts of the bill, which is the section 1, A, B, and C. So your grammatical construction is faulty because an act refers only to the title of the bill.
I understand that without question. But when you have a without and then you have a with, it begs question. Thank you. Thank you, Mr. Chairman.
Representative Bourgeon.
Thank you, Mr. Chairman. Could someone, what triggers a meeting of the Legislative Coordinating Council? Do they meet on a regular basis? If a decree happen, would a meeting be called? How does that work?
So the Legislative Coordinating Council, and Mike, if you are more aware of them than myself, feel free to let me know. But the Legislative Coordinating Council operates in the interim, typically when the legislature is not in session. All of our elections happen in the fall, August and November. So it stands to reason that the legislature will not be in session when something might happen outside the legislative session. Now, we could, amend this to where if we are in session, then the whole body has to accept or decline or whatever. But, is that something that we want to do? Not, that's up to the will of this committee. The LCC has the authority to call an emergency meeting and have those types of meetings, and it is made up of both House and Senate leadership on both the majority and minority party.
Mr. Chairman.
You're welcome. Further questions for the reviser? Seeing none. Thank you, Mike, for your help. All right. So I have no proponents listed. And so what I will probably do is craft some written testimony and have that submitted to you guys. And I will go ahead and just join the proponents list and join the written testimony for that. Are there any proponents that wish to speak to the bill that are either in the room or online? I'm not seeing any, so I'm going to go ahead and close the proponent section. We're going to go ahead and open the opponent section, and the chair recognizes Davis Hammett, Loud Light Civic Action Group.
Hello, Mr. Chairman Carpenter and members of the committee. Thank you for letting me join you today. There's a couple of points I want to go over. I'm actually going to go in reverse order from how my written testimony is because of the conversation I had with the reviser. The first part that's concerning to me about this bill is repealing 25-622, which is essentially a crisis management law. What it allows is that if, an act of terror happened or if a tornado wiped out an entire town, and that was right before an election, so it would be impossible to hold the election in a conventional manner. It would allow the Secretary of State to make emergency adjustments to ensure that those people are not disenfranchised. This is especially important whenever you think of federally protected communities and other stuff. You have civil rights concerns that you might essentially just be blocking an entire neighborhood from voting, which could obviously lead to litigation and other stuff. And just on a practical term, the idea of taking away a crisis management tool is concerning, especially since there's nothing being put in to replace that. On the other parts of the bill, on Section 1B and really Section 1C, all throughout this, there's a lot of concerns about the separation of powers. And this is from the US Constitution and the Kansas Constitution. Section 1B, there's a judicial review concern because it essentially says that the courts no longer have any place in election law. This question was actually brought up during previous discussion on this, which is really what does alter mean? And I think that could have a big consequence for if this entire bill is unconstitutional or not, because to me reading it, it seems like it's an encroachment, an unconstitutional encroachment saying that the court doesn't have a right to review. On Section 1C, there's a separation of power concern related to executive enforcement. And the Kansas Constitution, Article 1, Section 3, states that the supreme executive power of this state shall be vested in a governor who shall be responsible for the enforcement of the laws of this state. So again, just encroaching on that because you're trying to regulate how the executive branch can enforce laws. And there's an additional concern related to how this deals with the Secretary of State. Federal law under the National Voter Registration Act designates the Secretary of State as the chief officer of elections. And as this pertains to federal law, the idea that the Legislative Coordinating Council would be able to essentially interject itself between a federally designated officer and a federal court. Again, that just seems concerning to me. And I think there's a lot of legal questions around this. So from my perspective, it seems to take away a crisis management option for elections and open up a whole slew of questions of constitutionality and separation of power and federal and state separations and jurisdiction. So with that, I would recommend this committee oppose this bill, and I'm happy to stand for questions when appropriate.
Questions, Representative Proctor.
Thank you, Mr. Chairman. So I'm glad that you did discuss in your testimony both the U.S. and the Kansas Constitution. I think the fundamental principle in both of those documents is first that decisions that affect people's lives are made by elected officials, not unelected officials, but also that no one person wields unchecked power, that every person's decision is subject to checks and balances from a co-equal branch of government. And so my question is, what is the issue with having the legislative branch have some check on the power of the other two branches when it concerns elections law? Every other kind of law, we have those checks and balances. Why is it not appropriate in this case?
So the checks and balances are still there. For example, y'all could come back and a law could be struck down as unconstitutional, and you could try to later adjust the law to make it constitutional. My concern about this is it appears to say, again, I don't know, but it appears to say that the judiciary essentially just doesn't have jurisdiction over Kansas state election law. Again, this is about how broadly are you defining alter, which I believe the reviser said, again, this is kind of unclear. It would probably have to be litigated. So it's that idea of essentially trying to like preempt the judiciary. And then on the enforcement clause, again, you could come back and say, you know, the governor or the Secretary of State was wrong, and you could adjust the law. But the idea that you could essentially just immediately intervene without actually having the legislature present to pass a law, that doesn't seem like an imbalance, right? Like every year this session is convened to do a check and balance, and y'all can investigate the executive or judiciary and try to make adjustments. But this just seems like it goes beyond that in a potentially unconstitutional manner.
Thank you, Mr. Chair. I'd like to follow up on that. So the example that you drew on from the statute is that emergency situation. And you're not going to be able to bring the entire legislature back to address an emergency situation. And by the time they all could come back, it would seem to me that it would be a moot point. The alteration, the irrevocable alteration will have already been made in fact in an election. So this body, the Legislative Coordinating Council, is designed to address issues that come up until the legislature gets back in session. So I would just say, I agree with you. Ideally, we'd just be sitting here all the time waiting to address these issues, but I don't think that that's necessarily a good use of taxpayer dollars.
All right, are there any further questions? And remember, body, this is a hearing. We need to ask questions. We can debate the bill if we get to that point. So are there any further questions for the opponent? Seeing none. Thank you, Mr. Hammett, for your time this afternoon.
Thank you.
I'm going to go ahead and close the opponent section of this hearing, and I'm going to go ahead and open up the neutral section. And I have listed Katie Capal, Deputy Assistant Secretary of State. Welcome to committee.
Thank you, Mr. Chairman. Members of the committee, I'm Katie Capal. I'm the Deputy Assistant Secretary of State for Communications and Policy for the Secretary of State's office. As you will see in our written testimony, unless there are extenuating circumstances, the general policy of our office is that we remain neutral in legislation introduced by third parties. Out of respect that you guys are the policymakers, and we believe we're in a position to work with you to answer questions, offer insight, background, historical information on how the policies under consideration could impact our office or Kansas elections. So with that, we are neutral on House Bill 2183, but we do offer two suggestions. The first is we would raise the option of striking election procedures that appears in subsection C, particularly on line 15. We believe that phrase is too vague and is sufficiently covered by the preceding phrase discussing election laws. Our second and more pressing concern is that should you move forward on the bill, We respectfully and strongly ask for your consideration of the amendment contained in the box in our written testimony or some variant of it. What it would do is retain the Secretary of State as the designated point of contact with authority to address emergency situations specifically involving overseas and deployed military ballots. Under KSA 25-1223A, the Secretary of State is the designated office responsible for providing information regarding voter registration procedures, absentee ballot procedures, and other information for absent, uniformed services, or overseas voters. In its current form, we believe House Bill 2083 strikes the Secretary of State's office as the designated point of contact. For record, the Federal Voting Assistance Program was established by the United States Department of Defense to oversee the provisions of the Uniformed and Overseas Citizen Absentee Voting Act, commonly known as UOCAVA. The Department of Defense strongly recommends that each state have a designated point of contact with authority to address certain emergency situations involving overseas and deployed military ballots. Without this amendment or something similar, Kansas could run afoul of federal UOCAVA laws and be subject to intervention by the Department of Defense and potentially the U.S. Department of Justice. Although we believe this legislation is well intended to clarify emergency powers of the executive and judicial branches, it does create a serious void as to who would be responsible for ensuring overseas and military ballots get those ballots in emergency situations. So again, we're neutral on the bill. We just we believe it's very important that we retain the emergency powers for the UOCAVA voters, and I'd be happy to stand for questions at the appropriate time.
Thank you, Ms. Kopal. Before I open it up to the committee, I do have a few questions for you.
Sure.
Number one, it does strike the emergency power under 25-622 for the Secretary of State's office in this piece of legislation. My question to you, did anybody come and request to your office last election cycle to declare an emergency so that you guys could alter or move election timelines or make it all mail-in ballot elections?
Mr. Chairman, if it's okay, I'm going to defer to Clay Barker or Brian Caskey, our Deputy of Elections. They're both in this room with me today and can provide better context to that question.
The chair recognizes Mr. Barker.
Mr. Chair, back in March, April, May of 2020, we did have a number of people, and they were serious and well-intended, who interpreted the statute and urged the secretary to consider shutting down all polling places for at least the primary and going to an all-mail ballot election. They read the statute somewhat broader than we did. We interpreted the word impossible in the statute to mean that it has to actually be impossible for a voter to get a ballot before this could be triggered, though that's a debatable word. So yes, that was brought up, and this statute does give the secretary apparently very broad authority, though we believe it was initially passed in response to a polling place that was surrounded by a flood on election day. The county election officer did what they had to get the ballots out. This was passed later just so the secretary could ensure acts like that were consistent with statute.
Thank you for your response. And just real quick, one follow-up. Has this ever been used, and how long has it been in effect?
It's been in effect since, I believe, 1998 or 2000, excuse me, and it's never been used.
All right, thank you. Committee questions. Representative Proctor.
Thank you, Mr. Chairman. I've got a question for Mr. Barker as well. So the issue was brought up here when we were talking to the reviser that potentially this would remove the ability of the Kansas Supreme Court to strike down election laws that were unconstitutional. What's your opinion? Is alter versus strike down, are those two distinct activities of the judiciary in Kansas state law?
Representative, we didn't draft the statute, so I don't completely know what the intent was. We believe that There's a difference between the core judicial function of interpreting laws, issuing injunctions, striking down a law for being unconstitutional, trying to remedy two inconsistent laws, typical judicial function, as opposed to changing the substance of a law, where the court could say, well, though the statute gives you 3 days to do something, we're going to make it 10 days. Now, I don't believe that power is completely removed because of, I think, the intent of the consent decree portion was that the secretary could enter into an agreement with someone, apparently as long as the LCC agrees with it.
Okay, Representative, are you good? All right, Representative Miller.
Thank you, Mr. Chairman. With regard to election procedure, doesn't the Secretary of State currently have, there are laws that prescribe certain election procedures, but then doesn't the Secretary have wide authority to prescribe certain procedures as to how to administer elections? And don't you, in fact, issue rules, regulations that involve procedure to the local election officials?
Right. Representative, I'll give a partial answer, then I'll pass it off to the elections director, Mr. Caskey. One thing we noticed when comparing Kansas to other states during the last election is we have a very flexible and adaptable system. We have mail ballots, early in person, polling place, drop boxes, a lot of tools that can be used and balanced to respond to situations. We also give our county election officers flexibility to adapt to their local situation. You know, Johnson County and Greeley County have very different situations. They do things differently. We also give the county election officers the statutory power to change a polling place even on election day if they declare an emergency in the area. And yes, the secretary does have the ability to issue regulations, and Mr. Caskey always gives guidance to the election officers on basic procedures and recommended procedures. And I'll turn it over to him.
Thank you, Clay. Clay did a good job, so I will just give a short one-word answer. Yes, we do have that authority. There are at least half a dozen statutes that give explicit rule and reg authority of various election procedures in the Kansas Election Code, as well as we do have responsibility to provide policy and guidance across the spectrum as it relates to the administration of elections.
And I heard the term drop box. That's part of procedure right now, but I don't believe that term is even found in the statutes, is it?
You are correct. The word drop box does not appear in the Kansas Election Code.
But you do prescribe procedures as to the utilization of those, do you not?
In the run-up to the 2020 general election, our office did provide guidance and suggestion on the best way to deploy the drop boxes and to secure them. Yes.
And if this bill was passed, we wouldn't be outlawing drop boxes. It's just that the Secretary of State's office would have no say-so in how they were administered, correct?
That is something I think that we want to flesh out further. We do have a concern about the use of the word procedure in the current version of the bill.
And if an election was scheduled for April the 2nd and a tornado moved through the city of Topeka the night before and wiped out most of the polling places, with the passage of this bill, would you have any authority to address that circumstance? Well, let me ask you a twofold question. Would you currently have authority under 25-622 to address that circumstance? And without that statute, would you have any authority?
Representative, I believe, given your fact scenario, under the current statute, the secretary would have authority if he determined that it was impossible for people to get their ballots. That statute is pretty broad. It covers everything from war, disasters, all the way to equipment failure, and geographically from precinct to state, but it does have the word impossible to get ballots. Whether he'd still have the authority, I don't believe he'd have the direct legal authority, but he'd be able to give a lot of guidance to a county. And again, the county election officer has their own authority to move polling places around and perhaps change the timing that polling places are open also.
And given the circumstance I described, would that not be the kind of circumstance where the parties multiple parties would probably go to court to get direction on how to address that disaster situation.
I'd be speculating, but they could. It would kind of depend on what happened on election day itself.
And finally, Mr. Chairman, I hope this is final. Mr. Heim was floundering around a moment ago trying to come up with consent decrees that your office might have issued. I would expect you could tell me specifically what consent decrees you have entered into over the last many years, could you?
Yes, this is Brian. The last consent decree the Secretary of State's office entered into was in 2010. In 2010, it was a result of 7 counties in Kansas transmitting UOCAVA ballots to members of the military and overseas citizens later than the 45-day requirement. There were 7 counties that missed that 45-day requirement. The Department of Justice reached out to us and strongly encouraged us to enter a consent decree, or they would have filed lawsuit with the Secretary of State's office as the defendant. So that is the most recent example of a consent decree that this office entered into with the Department of Justice.
And that gives us a good example of when consent decrees are utilized, they're utilized to resolve disputes that have already become legal in nature and the parties agree to end it rather than leave it in the hands of the court. Is that fair?
In the 2010 version, yes, that is correct.
Do you have any more before that of note?
I think there was a similar situation that occurred about 10 years prior to that with only 1 county involved. I'm not sure it got to where a formal consent decree was signed. Rather, that's the path the Department of Justice took, and we all agreed. And so I don't think it actually was signed. I've been looking for a couple days now, and that's the only signed consent decree that I've seen in the last 25 years.
And if I may, Mr. Chairman, my final question. Has the Secretary of State modified his position from a few weeks ago when he told this committee that the election of 2020 ran quite well and he would recommend we make as few changes as possible? That's how I perceived his testimony. He was not recommending any changes, nor was he noting any particular problems that needed to be addressed. Is that fair?
That's fair. We stand by that statement.
Thank you.
Further questions from the committee to the Secretary of State's office? Representative Topliker.
Not sure who I would direct this to, maybe someone there at the Secretary of State, but is there any limitation at all on what the Secretary of State could do with any of the election laws during an emergency or disaster?
Representative, right now, the way that emergency powers statute is written, I don't believe there is any check or balance on the Secretary of State's power. Somebody might go to court. There might be a realistic, physical limitation on what could and could not be done. It would just be the words of the statute itself. And I think the limiting word is impossible to get ballots. That would have to be the trigger. Otherwise, the Secretary is free to do anything he or she wants. And that's why it surprised us, though it is a plausible position that this statute would allow a secretary to order an all-mail ballot election if they thought it was impossible to get ballots out any other way.
Mr. Chairman, another part of that question to Mr. Heim. Mr. Heim, is the governor's office...
Representative.
Yes.
I would like to go ahead and close the neutral section before we can come back to you to address the revisor, if that's acceptable. Thank you. Are there any further questions for the Secretary of State's office? Okay, seeing none. Thank you so much to the Secretary of State's office. We'll be hearing from you very shortly again. Okay, with that, I am going to go ahead and close the neutral section. And now, Representative Topliker, go ahead and ask your question of the revisor, sir.
Thank you, Mr. Chairman. The question that I have is, in an emergency or disaster, does the governor have any restrictions on what the governor may order in an executive order concerning elections in current law?
The governor has a specific statute in terms of emergency management. I think it's Chapter 48. I don't have the statute in front of me, but the bottom line is elections are not specifically mentioned in that statute. I do know that. It is subject to some interpretation and so on. I don't know, I can get you a more specific, get you a copy of that statute if you want, but the powers of the governor were basically negotiated in a bill that was passed during a special session in 2020. I don't know if that answers your question or not.
I can actually lend a little bit of insight to this real quick. So up until last year, KEMA, the governor was issuing a lot of executive orders, executive actions. It had been talked about that she might issue an executive order under KEMA to provide for an all mail-in ballot election. During the special session this last year of 2020, we put a provision inside of House Bill 2016 that said that the person who controls election law or what have you will be the Secretary of State, and the governor basically does not have the authority or ability to issue an executive order declaring all mail-in ballot elections. So that was in House Bill 2016. We just extended it to the end of March. So that current provision is still active, but depends on how the KEMA bill ends up coming out and flushing out that way, I think. So you still have a question, Representative?
Oh, sorry. Just real quick. Yeah, that's a pretty specific example there, but I just meant broadly, does the governor have any restrictions on what she or he, whoever the governor is, during a disaster could order through an executive order to change any election law? I mean, even cancel an election during a disaster. Are there any restrictions in law, broad restrictions on what the governor could order in an executive order outside of what you just mentioned, Mr. Chairman, about mail ballots?
Mr. Heim, if you need some time to look at that, and could you provide that answer to the committee assistant so she can distribute it to us?
Sure.
Okay, thank you. Representative Bishop.
Thank you, Mr. Chairman. I would like to address this to Mike Heim. Looking at the bill and Section C, the Secretary of State shall not enter any consent decree or other agreement and so forth without the specific approval of such consent decree or agreement by the Legislative Coordinating Council. My question is, I assume the consent decree comes into play because an alteration, a change was made, and someone went to court. So if the consent decree is not approved by the LCC, where are we then? Is it back in the court? Is it appealable? I mean, what kind of status are we in if that is, the decree is not approved?
I think it would have to be litigated, but if the issue is the law valid or not, that requires a coordinating council to approve a consent decree. And if it's valid, the court the consent decree cannot be entered into. The purpose of that section, if I would make a comment, was there are some states that did enter into consent decrees to go to mail ballot elections to extend this past election cycle and so on. And I think the intent of that is to try and rein in that possibility in the state of Kansas. It didn't happen in the state of Kansas, but it did in some states.
Representative, does that answer your question?
I think the answer is that it's unknown.
Okay. Are there further questions for the reviser before we close out this hearing? Seeing none, I'm going to go ahead and close the hearing on House Bill 2183. We are now moving on to House Bill 2162. And this item is amending various portions of obsolete language in our election law. And I would like to call on Reviser Heim to go ahead and give us an overview of this bill.
This bill was actually introduced last year, and because of the short session, didn't make it through, but it was recommended by the Secretary of State, if I recall correctly. Anyway, new section 1, population data used in adopting senatorial and representative district boundaries shall be identical to the basically the federal census, and the Bureau of the Census, including adding, subtracting, shall not be used. There was a constitutional amendment that was passed that deleted adding and subtracting of military and students and so on. And this, I think, complies with that passage of that constitutional amendment. The rest of the bill is basically conformity with using the census data and so on. There is a section in number 4 dealing with credit unions, and that starts on page 2. And again, it's dealing with populations in terms of determining the size of a credit union and so on. And it uses census data that needed to be basically a cleanup of that type of thing. The amendment on section 5 is to the Open Records Act. And again, it's a very minuscule amendment, which it strikes on page 10, 11306, which is repealed by, if you look at the repealer, a number of statutes are repealed because they are obsolete, and that amendment to the Open Records Act is simply to get rid of that one statutory citation on page 10. And I will try and answer questions. Secretary of State, I think, is in favor of this bill.
All right, Mike, real quick. You said this was a Senate bill last year. Did they pass it on the floor? Or did it come over to the House? And if so, what was that vote? Do you know?
Let me look it up real quick. There was 2 bills last year. There's another bill, and they were combined in the Senate. And I believe they did get to the House committee. But let me look up the bill real quick.
Okay. Well, the Secretary of State might have that already number on hand. So does anybody else have any questions for the reviser? Representative Neighbor.
Thank you, Mr. Chair. Question on the credit union. Is this just for census, or I know we had the bill we passed last year working with banks and credit unions. So is this something that was missed or should have been in that bill? You said you brought 2 bills together, so that's why I'm asking.
The credit union, this bill kind of was the credit union section was a red flag for some people, thinking that it was doing more than it did. The vote on the bill in the Senate was 36-3, and it did get to the House, and we actually had a hearing in the Elections Committee last year. But the cleanup in the credit union statute is just that. It's purely technical.
What are some of the, okay, tell me what some of the technicalities are, because I know we spent a great amount of time discussing this over an interim and then last year there was a lot of conversation on this, and I know they came to an agreement with the banks, and so I just want to make sure that if it's just
If
technical.
you would
make
look
sure
on
that's-
page five of the bill, line 35, the the only amendment of any substance, and this is not a substance amendment, but it refers back to section 1. It's when there's a definition of population data, and it refers back to section 1. And section 1 is where they use the federal census period for population kinds of issues. That's the sum and substance of the amendment. The rest of it is any other markings you see are technical, strictly technical in terms of instead of saying subparagraph C, paragraph 1, it's now B1C. So, I mean, these are revisor things that are done, but the amendment was on page 5 in line 35.
Line 35. Thank you for your explanation. I just wanted to make sure that the context was what passed out of the committee and there weren't any surprise changes. So thank you for
No, and
that.
that was a concern last year.
There was a lot of hoopla around that because it said credit union with everything going on. But the credit union bill has made it out of the Senate and is over in the House now. So hopefully they will leave our bill alone in that regard. Are there any other questions for the revisor at this time? Representative Berquist. Oh, if that was not were you raising your hand? Okay. Representative Miller.
Mike, when I prepare my brief for my caucus, would it be fair for me to describe this bill as merely cleanup?
I would say it's technical and cleanup both. There is a bill brief from last year that I'll email you.
Yeah, I think I'll stick with my version. Thank you.
That's good.
All right, we're going to go ahead and move on to the proponents, which is the Kansas Secretary of State's office, Mr. Clay Barker, who's the Assistant General Counsel. And, well,
Mr. Chairman, I'm sorry to interrupt, but somebody's phone went off and they owe us treats.
yeah, I think that might be the revisor, maybe. Anyway, all right, so I'm going to go ahead and open it up, and we're going to be in the proponent section, which is Mr. Barker. Welcome to committee.
Thank you, Mr. Chair. Great to be back. As Representative Miller said, we see this as just a cleanup bill that follows the passage of the constitutional amendment in 2019 that ended the Kansas practice. We were the only state that did this, of taking federal census data and adjusting it by statutory directives. What this bill does, it has 3 essential parts, and the revisor went over this somewhat. I'll just go over it again briefly. The first part is the new section 1, which states that any time census data is referred in statute, it is the federal census data. No longer adjusted data exists, so you can't reference that. That's especially important for redistricting because the statute currently says you redistrict based state legislative districts based on the adjusted data, and there is no adjusted data any longer. The second part then deletes all references to how to adjust data and references to the adjusted data in the statutory code. Most of it's just deleting statutes that would tell the Secretary of State how to go ahead and adjust the data. It's quite a lengthy and involved process, but that no longer has any relevance. And then in this 12-page bill, probably 11 pages of it are these 2 statutes where there's just a de minimis change. There was a reference to, I think, 11306. That statute no longer exists, so that had to be struck and replaced with a different reference. And that's in the Consumer Union and a CORA bill. But it's just a tiny de minimis change, but it takes up a lot of pages in the bill. And the third part of the bill is, as long as we were working on census data, there is a section in the Kansas statutory code that had to deal with the one-time only 1988 state conducted census. We used to do it by counties, and one time we tried doing it at state level, that flopped. And those statutes should have been repealed probably 30 years ago, and they've stayed in the code. And every 10 years when the census is taken or there's redistricting, our office gets a lot of questions because people are confused. They read that and think somehow it still applies. So as long as we're cleaning up census statutes, we thought we should eliminate those. It just makes it simpler for the average citizen, resident, taxpayer to read the statutes and understand them. And as it was pointed out, this, though it was combined with some other statutory changes, passed the Senate 36-3 last time. There was no real opposition to these census changes. And with that, I'll stand for any questions.
All right. Are there any questions of the Secretary of State's office? Well, actually, I do have one real quick. So do you believe that if we do not act quickly and pass this and repeal those sections, that it might cause quite a bit of confusion or delay with redistricting and our committees regarding redistricting later this year?
Mr. Chair, it could. Because right now the statute says you do your redistricting based on adjusted census numbers. I mean, redistricting for state legislative districts, federal districts are always federal data. I think we all know that you can't do that because that data doesn't exist. It would take 2 years to get it all put together. So we need to change that statute.
Further questions of the proponents? All right. Pretty self-explanatory. All right, thank you, Mr. Barker. With that, I see no other proponents listed. Do I have any others that wish to speak as proponents? I want to go ahead and close that section. Are there any opponents or neutrals? Seeing no opponents or neutrals from anybody, those sections are closed. And I'm going to go ahead and close the hearing on House Bill 2162. Committee, I would like to feel you out and see where you're at on this. House Bill 2162, which we just heard, I believe is of a pretty non-controversial nature, but I also believe that we need to try to get this to the floor as quickly as possible because of redistricting and stuff. So I was curious to see if the committee would be willing to suspend the 24-hour rule and we can work this now. Representative Miller.
I would move the rules be suspended. We advance this measure of consideration for today, and I would move that it be passed favorably.
All right, we're going to start off with suspending the 24-hour rule first. Do I have a second? Second from Representative Collins. All those in favor? Hold on. Let me pull up the people on the grid so I can see hands. Representative Parker, are you in your office? Thumbs up? Yep, okay. Yeah, I don't know about that. All right, so I'm gonna go ahead and say ayes and nays. Representative Parker, just raise your hand if you're an aye or a nay as we go through this. All right, all those in favor of suspending the rule, signify by saying aye. Aye. Nay, same sign. Ayes have it. The rule is suspended. We're going to go ahead and work House Bill 2162, and I'm going to go ahead and open it up for discussion. Does anybody wish to discuss this bill? Seeing none, do I have a motion? Representative Berquist. Oh. Representative Neighbor, sorry, I didn't see the hand.
That's because I'm left-handed. Mr. Chairman, I move that we pass out House Bill 2162 favorably for passage.
All right, do I have a second? Second from Representative Berquist. All those in favor signify by saying aye. Aye. All opposed, no. Ayes have it. It passes. And with that, thank you, body, for your attendance today, and we are going to go ahead and adjourn. Thank you.